2026. Having considered the submission of Mr. Rahman, learned counsel for the petitioner, this court has carefully gone through the petition and the documents placed on record and the impugned order dated 19/1/2026. It appears that notice was issued to the petitioner herein at his permanent address and also at his present address. And the notice issued to him at the permanent address returned with a report that his sister received the notice. For which the learned trial court has held that in view of the Order 5, Rule 15 CPC, notice deemed to have been served upon the petitioner herein, and as he failed to turn up, the learned trial court has decided to proceed against him ex parte. Under the given facts and circumstances on the record, and also in view of the submission advanced by Mr. Rahman, learned counsel for the petitioner, this court is inclined to dispose of this petition by directing the petitioner to file an application before the learned trial court to set aside the ex parte order. To vacate the order dated 19/1/2026. And on such petition assigning the reasons for his failing to appear before the court on that day, that is 19/1/2026, and on such petition being filed, the learned trial court shall consider the same in accordance with law, especially keeping in mind that the contention of the petitioner that though someone was received by his sister, the same was not communicated to him. In terms of above, this revision petition stands disposed of at this motion stage itself, and consequently the interim order dated 19/1/2026 stands interfered with.
Right.
When the next date is fixed?
Malo?
When the next date is fixed?
It's May, second week of May ballot, I will appear on 11th of May ballot.
Okay. Before next day.
Right.
May please, Lordship. My Lord, we have filed this CRP challenging the order passed by learned Civil Judge Senior Division at Dhubri. But before the impugned order, Lordship may kindly see page 20. The respondent herein filed a title suit against us, claiming that there is a small path passes through which they have to go to the main road. Now, Lordship, they have also made a picture drawing, page 20, Lordship, kindly see. Here, they have made their own picture. Here is no signature, nor they have of any public authority. Only for their own interest, they have made this. Now, we have collected the sketch maps which is prepared by the circle officer. Now, Lordship, kindly see page 62. A party portion, Lordship, may kindly see this is the original one, that is page 62. It is signed by circle officer. Page 62A. Page 62A, kindly see. Now, 937, diag number 937 is the land of the respondent. And 938 is the land of one person, Shamsul Haq. And 939, this is our land. 939 is our land. Now, Lordship would see from 937, there is a path, passage, touching diag number 924, 945. Lordship has seen, page 62.
Yes.
A. So, in 937, they have their own house. They go touching the footpath of the number 924 and 945, and thereafter go to main road, that is AM Road, Assam Match Company Road at Dhubri. So this is the road. Now our land is 939, there is no road. It is made by a government officer. There is no any, but they have drawn the picture at page 20. There is no, it is the drafting of the respondent that this is the road, but actually there is no road. Now we have our RCC building, and the building 938 is the land of Samsul, 938. So from 937 to, they have to come passing 938 tag number. That is the land of Shamsul Haq. He has also RCC building, and our land is 939 and 940. These are our land. We have also RCC building. So they want indirectly to destroy our house. Whereas they have the land of 937. There is a footpath, and it is duly signed by the circle officer. And their picture is signed by no public authority. Even then, on the basis of that picture, learned civil judge, now Lordship may kindly have a look to page 49, my lord. On the basis of their personal drawn up picture, the learned civil judge junior division has passed the order. The page para 18 may kindly seen. Page 49, para 18. The prayer of the petitioner is allowed, and the opposite party, their husband, their servants, agents, workmen, men, etc. are restrained from changing the character of the suit passage and from disturbing the use of the passage of the plaintiff petitioner and his family members till disposal of the main suit. So, my lord, this order was passed. Now, on what basis this order is passed? That is the basis of their own picture. Thereafter, my lord, we went to the learned civil judge senior division by filing appeal, and the learned civil judge passed order that Lordship may kindly see page 60. Operative portion I am reading only. Page 60. In the thread of discussion made in the foregoing paragraphs, paragraph 15, this court finds no merit in the appeal. The respondent has successfully established his right of ingress and egress over the suit pathway, and the learned trial court was justified in granting temporary injunction. So our appeal was dismissed.
Okay. First, you show me that the trial court has granted temporary injunction based on the sketch map.
Because, my lord, that is
Where,
evident because
in which part of the order it has been observed?
now that Lordship may kindly see page 42. In 34 years back, they have purchased the land. Since after 34 years, they have come. So, the petitioner had purchased, kindly see page 42.
No, that is the fact of the case.
Facts of the case.
I am asking you,
Yes.
in which part of the order the learned civil judge Junior Division has relied upon the sketch map furnished before him.
Because, my lord, they have no case at all, only
No,
still they have.
that is a different matter.
They-
First, you answer my
What
question.
title suit, what they have stated, that was cheat. Kindly see page 7, page 44.
Mm. Yes.
Notice was accordingly sent to the office. Office means the appellate.
Mm.
Appeared and filed written information. Office denied all the materials allegations of the petitioner
Mm.
and stated that the petition is barred by limitation as it is filed after 34 years.
Mm.
So since 34 years, my lord, they have no land, and what picture they have drawn up in their plane, that is unsigned by any public authority.
Mm.
So how, after destruction of the building or a part of the building, how we can give passage? There is no passage. So they are using the land which we have drawn up, which we have annexed in the CRP itself.
No, no.
And-
Nowhere in this order the trial court has discussed about the sketch map produced before it.
But the order was, injunction was granted.
Granted. Considering by having found all the three requirements in favor of the petitioner.
No, in favor of the petitioner, my lord, this is absolutely wrong. Because in between there are
Therefore, I am asking you how the impugn order passed by the learned civil judge is wrong.
wrong on the basis, my lord, there is no whisper about the passage which is there, which is duly signed by municipality. It is in the Dhuri municipality. So only it is said that prima facie case, my lord, they have their land, that is admitted. But where is the path? Now, whether the balance of convenience is in their favor, balance, they cannot pass over through destroying our building, and whether the plaintiff would suffer irreparable loss or injury. How they will suffer? Because there is a path which is touching their own land. Kindly again see page 62A. They would not suffer. So it is wrong finding. How
Okay,
it
we'll
is.
call for the record and we will examine. Let notice go at this.
No, my lord, one thing, Lordship, kindly
What?
consider 937, page 62, again kindly see, page 62. A.
No. I have, you have at the very outset, you have started your argument showing this annexer 62A, but you could not show that in the impugn order, the courts below have relied upon the said document.
They have no document at all, only on the basis of that drawing and their submission it is ordered.
Let notice.
So my prayer is this, nobody can obstruct any person's way. When there is they have 937 land, and with that land there is this passage, and it is drawn up by the circle officer, and that drawing is drawn up by the.
At the time of final hearing, we will consider that.
But now they are trying to destroy our house. Otherwise, they cannot go because they have to. But here, one thing, Shamsul Haq's land is in between. And thereafter, our land, they have not made Shamsul Haq a party in their title suit. I don't know why they may have some alliance. But thing is this, how they can come to, because Shamsul Haq is not by a party. Shamsul Haq is also RCC building. And we have also RCC building. So here is no way. Here is no passage, no path.
Okay, all right.
That's why, my lord, one thing is this, our building should not be disturbed. That may lordship kindly observe.
No.
Now they will disturb us, my lord.
No. In this petition under Article 227 of the Constitution of India and also under Section 115 of the Code of Civil Procedure, the petitioner has challenged the judgment and order dated 13/2/2026 passed in Miss Appeal case number 7 of 2025, passed by the learned civil judge senior division Dhubri. It is to be noted here that by the impugned judgment and order dated so and so, the learned civil judge senior division Dhubri has upheld the order, judgment and order dated 19 to 2025, passed in Miss J case number 95 of 2024, arising out of title suit number 63 of 2024 by the learned civil judge junior division number 1 Dhuri. It is to be noted here that by the impugned order, judgment and order dated 19 to 2025, the learned civil judge junior division number 1 Dhuri has granted ad interim temporary injunction in favor of the respondent herein against the present petitioner. Peruse the petition and the documents placed on record, and also peruse the impugned judgment and order dated 30 to 2026, passed by the learned civil judge senior division Dhuburi, and also the judgment and order dated 19 to 2025, major case number 95 of 2024, arising out of titles on number 63 of 2024, passed by the learned civil judge junior division number 1 Dhuburi.
Our
Let
building is in retail lordship.
notice be issued to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Rest shall call for the record of the learned courts below. Scan copy of the record by the learned courts below. List the matter after 4 weeks. Though, Mr. Mahmood, learned counsel for the petitioner, has right for granting stay of the impugned judgment and order dated so and so. Yet, having regards to the facts and circumstances on the record, his court is not inclined to grant then a stay of the impugned judgment and order dated so and so, passed by the learned civil judge senior division Dhuburi. However, the same will be considered on next returnable date list after 4 weeks.
My lord, one objection, our building may not be touched.
No. That kind of injunction cannot be granted.
So how they
This is
can,
not a writ petition. This is a civil revision petition. Yes, next item.
alright.
None appears for the petitioner on call. List the matter after 1 week. Now, after the vacation, in the event of subsequent non-representation, the appropriate order shall follow.
Your Lordship. As for office note dated 4/4/26, Your Lordship, the service to the respond number 8 has been served through dusty service. Accordingly, Your Lordship, an affidavit has been filed enclosing the copy of the receipt served to the respond number 8.
So service completed.
Service complete altogether.
Okay.
And it LCA record in both the cases, title suit as well as this case, has been received.
Received.
So it may come up regular hearing, Your Lordship.
Okay. Heard Mr. Sharma, learned counsel for the appellant. Mr. Learned counsel for the respondent number. Respondent number 2, 3 and 10.2. 10.2. Mr. Sharma, learned counsel for the petitioner, counsel for the appellant submits that notice upon respondent number 8. No, service of notice upon respondent number 8 was effected by Dastimut, and to that effect, an affidavit has also been filed. He received the notice.
Yes. Next page, annexure has been enclosed.
Mr.
Affidavit.
Sharma further submits that respondent number 8 has received the notice, but he failed to. No, but he remained unrepresented today. And since service has been completed and the records of records from both the court below have been received. The matter may be listed for hearing in usual course. Fair allowed. This is a list the matter for hearing in usual course.
Obliged.
In this case, the matter has been entered infrastructure. Order which they are challenging, the delay condonation application has been allowed. When the connected title appeal is pending. I have a copy of the order. The delay condonation application was allowed J 128 of 23, that third page, is allowed on 12 May 2025. And the connected appeal is title appeal number 22 of 2025, which is fixed on 11/5/2026. Aforesaid versus Rabizuddin. The decree has also been fully satisfied. When the Korean no, it is well. What do you
But according to you, this matter become infructuous.
Because now title appeal is pending. Title appeal is fixed on 11 May 2026. Because we will just revision now.
Hmm.
Lordship may fix the matter after vacation. I need to take some instruction in case something. Even July है हमें क्या? ये तो
Decree was executed.
Decree was also executed. Decree on 9/8/2024 is ordered the first page which I have given. It shows the decree has also been executed. Fully satisfied.
But stay was granted by this
On
court.
the 6th day, but this report is of 9/8/24. Prior to that, I think it's my as well. High Court also is of 9/8/24. This order is also 9/8/24. Same day.
Heard Mr. S. Ahmed, learned counsel for the petitioner. Then Mr.
As called for respondent 135
S.
678.
Found for respondent number 13567 and 8.
Yes, sir.
8. Mr. Khan has produced two orders passed by the learned Civil Judge Junior Division number 2 Nagaon in title execution number case number 18 2023. And on the strength of the said order, Mr. Khan submits that this matter become infructuous, and as such, he is contended to close the same. However, Mr. Roman, learned counsel for the petitioner, submits that the matter may be listed after due vacation, so that he may obtain necessary instruction from the petitioner. They are allowed. This is always the matter after vacation. And the order produced before the court today by Mr. Khan shall be marked as Annexer A and be tagged with the record.
29. Masuk.
11.
Yes, I for my lord, pray for fixing it for hearing my lord.
When do you want?
Lord, any date my lord after vacation my lord.
Heard, Mr.
A Zahid.
Learned counsel for the applicant and also heard Ms. K. Bhattacharya, learned counsel for the opposite party. This application is referred by the applicant. Oil India Limited, and 3 others for early hearing of the CRP number 47 of 2020. The learned counsel for the petitioner further summons that the CRP number 47 of 2022 may be fixed after due vacation on suggested date
As per lordship convenience, my lord.
19th of May. Any objection on 19th of May? Ms. Bhattacharya submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands disposed of, directing the registrar to list the matter on 19th of May.
Lordship, a small prayer. Lordship, the partnership deed has been reconstituted. So names of three petitioners may be struck off, Lordship, and we may want to include another party, Lordship. The new partnership deed, Lordship may want to produce.
No, so you have to file one IA to this effect then.
Lordship,
You file on next day.
Lordship. So we'll pray for striking of the names of respondent 1, 4, 5 and including.
In the meantime, you file the IA
Lordship.
before next date of hearing.
Lordship. Lordship, till then the interim may happen.
Is there any interim order?
Yes, yes.
No, we are not passing any order in the CRP.
Lordship.
We are disposing of only the IA today.
Always.
May it please your lordship. My lord, this is that senior citizens tribunal eviction matter, my lord.
Pardon?
Senior citizens tribunal eviction order that was
Yes.
passed.
Yes.
Lord, we are not under any interim protection, my lord, as on date. We've taken steps on the presiding officer of the maintenance tribunal. The report has not come, my lord. But that is a formal party. My only prayer today is, my lord, if your lordship may call for the records, because our moot ground was that the procedure was not complied with. So therefore, if the records arrive, then your lordship can take it up for disposal, because I have urgency that eviction order is still looming.
Because I prefer we better maybe kindly fixed in the month of May. Because I think everyone is busy with this action, but that's why, so this report is also irritated. You'll also fix it in the month of May for final disposal. I have no objection. May type of number.
So service upon
The
respondent-
presiding officer of the tribunal, my lord,
Is-
he's a formal party otherwise.
But the record has to come.
Records, if your lordship call for.
Heard Mr. Decker, learned counsel for the petitioner, and Mr. B.D. Kaur, learned senior counsel, assisted by Ms. Learned counsel for the respondent. After hearing learned counsel for both the parties, it is provided that recessal list the matter on suggested it.
25th of May.
No, my lord, earlier than that, I have an eviction order against. May 1st week or no?
21st of May.
My lord, by that time I'll be evicted.
14.
Short day? First week.
21st.
First week,
First week on any date. 5th.
5th of May. In the meantime, recessal call for the record
8th of May.
urgently from the learned.
8th of
Uh,
May.
Senior Citizens Maintenance Tribunal.
11th of 12th.
Senior Citizen Maintenance Tribunal.
Tribunal, Gauhati.
What?
Yeah.
When? Well,
Obliged.
Item 13.
May it please your lordship, and for the petitioners in the matter, actually, we are filing a fresh CRPIO under Article 227 and 151 of the CPC. It's against interlocutory order, that is MJ 28, regarding amendments, your lordship. So the trial court has mechanically rejected an amendment in the title suit number 52 of
no,
2014
today this IA is listed. IA is for condonation
for
of delay.
condonation of delay. your
Let
lordship.
notice go at this as this.
So due to, your lordship, this is a condonation delay of 854 days.
Yes.
And what has happened, the petitioners, they have a financial difficulty, so due to which they couldn't file a appeal for the same, for the correction.
Maybe. Let notice go at this as this.
Yes, sir.
Heard, Mr.
I think.
Learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 is prepared by the applicant for condonation of delay of 854 days in preferring revision petition under Section 115 CPC read with Article 227 of the Constitution of India, challenging the order dated 16/8/2023 passed in Midge case number 28 of 2023 by the learned civil judge junior division number 1 Nagaon in PS case number 52 of 2014. Let notice be issued to the opposite party returnable in 4 weeks. Opposite parties returnable in 4 weeks. Step by speed post and also by usual process within a week from today. List after 4 weeks. 4 weeks.
Your Honor, can you just give us a exact date? Otherwise, we have to again mention it if it's possible for us.
After 4 weeks, given that.
29th May.
All right, lordship. Published.
And then for admission. Item number 2.
May it please your lordship, my senior is on Lex in Code 6. May the item be taken up after some time?
After some time, but we have no matters now.
Any bit.
Kavi, or matters any? Okay. Okay.
Item 6.
May I please, your lordship, my lord, hearing this appeal, my lord, preferred against the order of the appellate court, wherein my condonation petition was rejected, my lord. That your lordship may found it page 63, your lordship. Delay of 36 days, my lord, in preferring the first appeal, my lord.
36 days.
36 days, my lord. The order starts from page 63, my lord. The learned court held that the petition, the appellant is failed to, that is page 68, your lordship.
Hmm.
Second para, hence, in view of the foregoing, I am of the opinion that the appellant could not prove sufficient
number?
cause for the file.
Page number
Page 68, my lord.
68. Yes.
Second para, my lord, hence, in view of the foregoing discussions, I am of the opinion that the appellant could not prove the sufficient cause for preferring appeal beyond the period of limitation. That is only 36 days, my lord.
No, maybe. In absence of any plausible explanation of why the court will condone the delay.
My lord, in fact, my lord, we have applied for the certified copy on 5/4/2025. That is That
Mhm.
opinion of the court is, my lord, starts from
Mhm.
66, my lord. Married, my lord.
Page number?
Page 66, my lord. 66. That is the opinion of the court, my lord, grounds stated by the appellant for delay in preferring the appeal
Mm.
is mainly due to the circumstances that decree was not drawn up till 4/4/25. Decree was not shown to be the appellant side, and as such, no petition for certified copy of judgment and decree could be submitted till 5/4/25. After the certified copy was delivered on 10/4/25, the appellant went to Impal, thereafter returned on 1/5/25, and subsequently there was a panchayat election on 2/5/2025 to 3/5/2025 and handed over the certified copy of the judgment and decree to Learned Council on 4/5/2025. In considered opinion of this ground, the ground stated by the appellant is not sufficient as to consider the same as a sufficient cause which caused delay preferring appeal for which the delay is to be condoned. The ground that the appellant could not apply for certified copy as decree was not drawn on 4/4/25 is found to be irrelevant and devoid of merit as because there is nothing on record to show that the decree was not drawn until 4/4/25. Further, it was the duty of the appellant to apply certified copy as because he had the knowledge that on 19/3/2025 the title suit was fixed for judgment. The appellant could not show as to what prevented him from filing simple application of certified copy when he very well know that on 19/3/25 the main suit was fixed for judgment and judgment was delivered accordingly. Further, the appellant, despite receiving the certified copy on 10/4/25, instead of taking steps for preparing appeal, went ahead with his visit to Imphal, Manipur, and after completion of visit, proceeded to hand over the certified copy of the judgment and decree on 4/5/2025. Engaged counsel, the series of circumstances narrated appellant very well establishes that his negligent lackadaisical attitude towards his approach in preferring the appeal. That he has applied the certified copy, my lord, within 30 days, my lord. That is certified copy, page 32, my lord.
Okay. Let us admit the appeal. Let notice go. Heard, Mr. Along Learned Counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure is preferred against the order dated 21/1/2026, passed in Nize case number 151 of 2025, entitled appeal number 19 of 2025, by the Learned Civil Judge Senior Division number 1, Kasar Silsor. It is to be noted here that the Learned First Appellate Court has dismissed the appeal on the ground that the delay of 36 days in preferring the appeal challenging the judgment dated 19/3/2025 and the decree dated 4/4/2025, passed in title suit number 9 of 2025 by the Learned Civil Judge Junior Division, Lakhimpur. Peruse the memo of appeal, the grounds mentioned therein, and also the impugned judgment and order, impugned order dated 21st of January 2026, passed in Nize case number 151 of 2025, entitled appeal number 19 of 2025, passed by the Learned Civil Judge Senior Division number 1, Kasar Silsor. This appeal is admitted on the following substantial question of law: whether the finding recorded by the learned first appellate court in respect of the sufficient cause, while refusing to condone delay of 36 days in preferring the connected appeal, suffers from perversity due to non-consideration of the explanation put forwarded by the appellant hearing for the delay of 36 days. Admit? No, not admit. Issue notice to the respondent returnable in 4 weeks, step by speed post and also by usual process written from today. All for the scan copy of the record from the court below. Place the matter of 4 weeks.
My lord, this is an appeal, my lord, the second appeal, in respect to order, my lord.
The one aspect I have to indicate will be a regular second appeal RSA, not SAO. Because the initial order passed by the London trial court on our application under order 21 rule 97 was a decree in terms of order 21 rule 103. So first they filed an appeal, which was the first appeal. Now it will be a regular second appeal because it is arising out of a decree. The registry is registered as a SAO. It should be a RSA on a regular.
Earlier also we have filed SAO. We have filed SAO. Because no decree is prepared.
No, it is a decree. Let us have a look at page order 21 rule 103. Registry may not understand so many legal things. So we kindly have a look at order 21 rule 103. It is a decree.
Orders to be dictated a decree. So no separate decree is prepared. The 103 provides that appeal.
103, yes. There are some decision of the Supreme Court also on this point.
Yes, that's absolutely correct. So it becomes a decree. So they have filed an appeal, which was the first appeal. Now it is the second appeal, so it will be a regular second appeal. The lordship may directly register to register it as a regular second appeal and then disseminate. Otherwise, what they have challenged is purely a question of fact. They have admitted that in execution, they have dispossessed us, although their crystal land is different from others. They have admitted also. And they have also said, if I am given back possession of my land from where I was dispossessed on the basis of that decree, they have got no objection. So it's a pure fact, madam. And last
that I shall argue.
12 years later.
No. Mr. Mazumdar, you say, if we direct the registrar to register it as a regular second appeal,
My lord.
then would it not be required to change the memo of appeal and
No, not required.
Possibly they have mentioned about one section 100. Otherwise, mentioned 100 also. First three is got the power. You want to know appeal under 1500. First page, first three pages. After the index page. This part they have rightly mentioned that. Fourth page. It will be a first page of the memo.
in which place?
Fourth page from the beginning, my lord. First, second, first, fourth. Memorandum of appeal on the 1500. That's I mentioned. So it will be registered as a regular KNP, RSA. Under section 100 it is
Okay,
started.
let it be registered as RSA.
I nothing to say, my lord, but earlier we filed as a SAO. Anyway.
The SAO, my friend says, SAO comes in 2-3 cases. One is supposing a first appellate court passes an order of remand against that appeal lies, so it becomes SAO, not a, because there is not a decree.
That is not a decree.
Because there is not a decree, my lord. It's an order of remand, it's not a decree, but appeal lies under order of rule 1, then it becomes SAO. There are other similar cases where SAO is filed, but this is regular second appeal. Because it's a decree, original order is passed under order 21 rule 97 is a decree in terms of order 21 rule 103.
So one caveat is also there.
Caveat, we filed the caveat.
So today
The caveat and then direct the registry to register it as a regular.
we may dispose it of.
Yes, and list it up for a
Caveat wrote the art, for instance, research. Art, Mr. G.N. Sayola, learned senior counsel, assisted by Ms. Cabot Assistant, learned counsel for the appellant. Then Mr. D. Mazumdar, learned senior counsel for the respondent, assisted by Mr.
G. Datta.
Learned counsel for the respondent. Mr. Mazumdar, learned counsel for the respondent, has pointed out that the order being challenged in this SAO amounts to a decree under section 100 and under order 100 rule 103 order 21 CPC, and as such appeal will lie against the said decree, and it ought to have been registered as regular second appeal instead of SAO. And as such, the registry may be directed to register it as RSA.
Right.
Mr. Sayola, learned counsel for the appellant, however, submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that register this SAO as regular second appeal and list the matter before this court immediately after reopening of the vacation.
Okay. Date we fix now.
20th, my lord. 21st.
21st I got something. Let it be 24th.
24th. Okay.
24th. Okay.
Standing item 2.
Ma'am, because I have had an affidavit also regarding withdrawal of our wakalas.
Sorry.
That didn't start. From Esther,
When it was served?
15/3/2026.
Heard, miss, your name, please?
My name FL Mizo,
Learned counsel appearing on behalf of Mr.
AJ Atya,
A.J. Atia, learned counsel for the petitioner. Then also heard Mr.
M. Borolo.
N. Bordolo, learned counsel for the respondent.
M. Borolo.
Bordo, M. Bordo, learned counsel for the respondent. Mr. Bordo submits that he is willing to withdraw his Ukalatnama from this case, and he has already issued one notice to the respondent, and the same was served upon the respondent on
18/3/2026 also.
18/3/2026. Accordingly, Mr. Boru is allowed to withdraw his Ukalatnama from this petition. A registrar issue notice to the respondent, returnable after 4 weeks. Who will take his step? They will take his step. Registry will issue.